Hello everyone, my name's Stella Wong. I am a patent lawyer from Hogan Lovells in London, and I'm joined by my colleagues, patent partners, Miriam Gundt from Hogan Lovells in Düsseldorf and Ruud van der Velden from Hogan Lovells in Amsterdam. Today we'll be talking to you about European patent litigation, in particular the key considerations ahead of such action, the key differences between the Dutch, German and UK patent systems, along with some tips for success. But first, what is a European patent? Well, it's applied for, examined and granted centrally by the European Patent Office. However, upon grant, it is not enforceable in a single court. It has to be enforced on a country-by-country basis, and it's essentially a bundle of national rights. Now, whilst the term of the patent, 20 years, and the grounds of validity are the same across Europe, the interpretation of those grounds, the infringement, and the remedies are all left to the national courts to decide. And so it's not uncommon to have differing decisions across Europe for the same European patent. In addition, it's possible to oppose a patent once it's granted. Within 9 months, any party can oppose it before the European Patent Office. And in these circumstances, the proceedings before the European Patent Office are central. So if it's revoked in a final decision there, then it's revoked throughout the designations. The proceedings before the EPO are very slow. So the scenarios that we'll be thinking about today are two, really. One is if you are the patent owner for example, a patent claim to a catheter or a stent or an injector pen, and you've spent years on research and development of that product, you exploit it, you manufacture and you sell it in various European jurisdictions, and you're very successful in that because you're the only one on the market. And then along comes an infringer. You understand from market intelligence that an infringer is about to launch in your key jurisdictions, and that is going to erode your market. So the question is, what can you do about it? In these circumstances, the patent owner will think about a litigation, an infringement action in its key European jurisdictions, seeking an injunction to stop the infringer selling its product and eroding its market, and also if the infringer is already on the market, perhaps some damages. The second scenario is if you are the potential infringer. So you have a device or you use a process that might fall within a patent claim. You want to be free to sell your product across Europe. And so the actions you might be thinking of then is a revocation action. So that is to say that the patent is invalid in the key European jurisdictions, or alternatively, a declaration of non-infringement. And in this way, you will be clear to sell your product without the threat of an injunction stopping you. So you'll have commercial certainty. Those are the two scenarios that we're thinking about today. And on to the big picture considerations. This slide is really from the perspective of the patent owner. So you've got a claim, for example, to a device. The first thing you're going to think about is where are you going to sue? Where can you validate your patent? You'd be thinking about where the infringer is manufacturing. Is it possible to sue in that jurisdiction so that you can stop the infringer at its source? You'll also be thinking about your biggest markets because you're going to want to stop the infringer eroding that market. And also, what information have you got about the infringing activities? Have you got enough to launch an action in the relevant jurisdictions? Secondly, there's timing. Which is the fastest jurisdiction? What's the timeline for the launch of the infringing product? And also bigger picture things such as expert evidence and disclosure. And the chance of success, the strength of the patent may well depend on the jurisdiction So you need to think about which jurisdiction you are most likely to have a valid and infringed patent. And then there are other factors, such as which entity is doing what activity. You need to sue the right entity. You need to think about the types of infringement that might be occurring and anything else that you could be doing, such as a customs seizure. I'll now hand over to my colleague, Ruud van der Velden, who'll talk about preliminary injunctions.
Thanks, Stella. The quickest way to put pressure on an infringer is to bring preliminary injunction proceedings, and such proceedings are available everywhere in Europe. In the UK, Germany, and the Netherlands, it typically takes about 1 or 2 months to obtain a decision. If the case is very urgent, then judges are often willing to act even faster. It is required, though, that the patentee acts quickly. As a rule of thumb, judges in the UK and Germany require that the patentee brings the preliminary proceedings within about 1 month after the patentee becomes aware of the infringement. In the Netherlands, this period is about 6 months. When deciding on a preliminary injunction claim, the UK judge will not do a mini trial, but he will conduct a balancing of interests based on commercial factors. A preliminary injunction can, for instance, be granted if there would otherwise be irreversible price erosion for the patentee, or if it is likely that the patentee would not be able to recover damages later. The preliminary injunction will be in place until the full case is heard. It works differently in Germany and the Netherlands. There, the judge will assess whether the patent is valid and infringed. In Germany, this normally means that the patent must have survived opposition proceedings in first instance. This is not required in the Netherlands, where the judge will assess the validity by himself, also in the absence of an opposition decision. The judge will also assess whether the infringement is sufficiently proven, so the patentee must bring a strong case in order to be successful. Decisions of the UK, German, and Dutch courts are very respected, and if one of those courts renders a decision, then the other courts will usually take this into account. Then we move on to the next slide about ex parte injunctions. These are injunctions without the infringer being heard. Ex parte injunctions are available in Europe, but in practice they are quite rare. Occasionally they are granted in relation to trade fairs. A very interesting option is the concept of cross-border preliminary injunctions, which are available in the Netherlands. Dutch judges are willing to grant an injunction not only for the Netherlands, but also for other countries, provided that at least one of the defendants is located in the Netherlands. In many cases, a Dutch defendant can be identified. Many international companies have a subsidiary or a distributor in the Netherlands. If that is the case, then the judge can also grant a cross-border injunction against foreign companies. It is required, though, that the case concerns the same patent and the same product. A recent example is the Novartis versus Mylan case about a medicinal product called X-Jade. Novartis sued a Mylan entity from the Netherlands as well as Mylan entities located outside the Netherlands and obtained a cross-border injunction covering 25 European countries. So with one single proceeding, Mylan was effectively barred from entering the market anywhere in Europe. So the cross-border injunction is a very powerful and cost-effective action that puts a lot of pressure on the infringer. And we now move on to proceedings on the merits.
Thanks, Ruud. So when we talk about proceedings on the merit, we're really talking about the validity and infringement proceedings. And in the UK and the Netherlands, these are heard together. That's not the case for Germany, where the system is bifurcated. In Germany, infringement proceedings happen first, typically within 8 to 15 months of starting the claim, depending on the court that's selected. And validity proceedings are heard later, around 2 to 2.5 years after starting the claim. In the Netherlands and the UK, the validity and infringement proceedings heard together are typically, at first instance, take 12 to 15 months, although in the UK this can be expedited if there's a good reason to do so. In terms of expert evidence, in the UK this is absolutely essential. It can make or break your case. Experts will be required to provide at least 2 expert reports, and will be cross-examined on them and other issues at trial. In Germany and in the Netherlands, expert evidence is not required, but it can be helpful. On to evidence gathering. In Germany and the Netherlands, it's possible to raid third-party premises in order to seize infringing material. This can be the infringing product itself or documents related to it. The threshold for seizure is a reasonable suspicion of infringement. The evidence must be within the jurisdiction of the court. Once that material has been seized, it's under the control of the court, and the patent owner must apply to the court for its release using a court-appointed expert. In the UK, disclosure is pretty much standard, but it's not the fishing expedition that is seen in the US. It's a much reduced version of that. Initial disclosure is required with the pleadings, so with your claim form and your defence, and there is the possibility of extended disclosure further down the line. The defendant will have to provide disclosure in relation to its infringing or allegedly infringing product or process. It has the option of, instead of providing that disclosure, providing a technical document called a product or process description. The material that is seized in Germany and the Netherlands can be used quite widely abroad, whereas in the UK, disclosure is for the purpose of those proceedings only. However, any reference to that disclosure in a public hearing can be used abroad. Finally, all European jurisdictions are happy to receive US 1782 discovery. That is when the US court orders disclosure for use in foreign proceedings. I'll now hand over to Miriam.
Thanks a lot, Stella. Well, for the time being, so far we have focused on the patentee's perspective and on how rights can be enforced most effectively. Now let's put ourselves in the position of a potential infringer and look at what you can do to avoid an injunction or avoid litigation altogether. Can you put on the next slide, Stella, please? So if you receive an infringement action or a PI request, there are several lines of defense that are open to you. You can argue a lack of infringement, including, for example, a prior use right, or a lack of validity. Of course, formal defenses are available, such as the lack of standing. Further, in the UK and the Netherlands, there is a special defense, or I should say a preparatory defense, which is called an error declaration. These are actions that are aimed at a declaration that a product of the applicant was obvious as a specific date, which then again means that any patent or a claim of a patent covering that specific product would be invalid. This type of action can be used where the patent is not even granted or not even applied for. I leave it at this point now, but we're happy to respond to questions in the Q&A session, especially Stella and Ruud, who know more about that process. Regarding preliminary injunctions, there can be a discussion, of course, around the balance of interests, or in the UK, the infringer also has the opportunity to apply for an expedited trial to argue that, in fact, there is no risk of irreparable harm. Finally, there is a question whether an argument can be made that an injunction would be disproportionate. Next slide, please. In the UK, an injunction is designed as a discretionary remedy, but in fact, injunctions are always almost granted. In continental Europe, in contrast, no discretion is available in the first place, so injunctions must follow as a result of a finding for infringement. One thing that you should know or keep in mind in this regard is a new initiative in Germany for legislative changes that aim at allowing proportionality considerations specifically. This initiative was initially designed for or aimed at cases where non-practicing entities, or trolls as we sometimes call them, bring cases, and for scenarios where, for example, a patent that is aimed at a very small part, such as a chip, would effectively be able to stop the sale of a much more complex product, such as a whole car or a telephone. These considerations, in my view, can also be applied for medical devices, and we have already seen some non-practicing entities trying to aim at, for example, connected devices. Equally important in this context is that not only proportionality considerations in the narrower sense are aimed at, but also third-party interests are specifically allowed. It's not clear yet which interests are specifically meant, but you could think of, for example, patients' interests or the interests of sick funds or public health as a whole. Which brings me to the final point, really. The last thing I wanted to mention here is the possibility to obtain a compulsory license. Compulsory licenses are in principle available where there is a public need for a specific device or a specific treatment. The requirements for compulsory licenses are very strict, and compulsory licenses are hardly ever granted. Therefore, I think that there is a clear tension between this new initiative that I just described and the institute of a compulsory license, which has very strict requirements and set law. Whereas this new initiative seems to allow the same kind of argument simply as a defense against an infringement action. Again, I will leave it at this here, but happy to discuss that in more detail in our Q&A session later on. Next slide, please. So, wrapping up, what can you do in preparation to secure your product launch? First thing, you need to win at the EPO. EPO opposition proceedings are really the cheapest and most effective way to get patents removed, and get them removed for the whole of Europe instead of afterwards going for national nullity actions. Secondly, protective letters. Protective letters are a preparatory defense aimed at avoiding at least an ex parte injunction. What you should keep in mind here is that in Spain, the protective letter will be disclosed to the patentee, whereas in all the other countries where that specific tool is available, the protective letter will only be revealed to the patentee if and when a request for a preliminary injunction is actually brought. Next thing, important to retain experts, especially for the UK, as we have heard from Stella. This is very crucial. Consider very carefully any statement about the timing of your commercial launch, as this may be a trigger point for a preliminary injunction request. Then national revocation actions, recommended, of course, for any patents that survive opposition proceedings in the EPO. And national revocation actions are required in Germany. As Stella has explained, infringement and validity are not heard in the same proceedings, but these are separate proceedings in front of separate courts. So the infringement court can only take into account any invalidity arguments if a corresponding invalidity action is actually brought. In Germany, this is only possible where the EPO proceedings have already been concluded. Another aspect that you should consider in the context of national invalidity actions or revocation actions is one thing that we have touched on earlier. Consider filing a nullity action in a quick jurisdictions to get or to obtain a favorable decision, which can then be taken into account by other jurisdictions, and that also may give you some leverage for a settlement, for example, in case that is even an option. Compulsory licenses, I've mentioned, consider that carefully on a case-by-case basis. Check your distribution channels. This is important, especially for the cross-border injunctions. And lastly, or that is even maybe the first thing that you should keep in mind, FTO analysis. make sure that you know your competitor's patent portfolio and start early to develop non-infringement and invalidity positions. And if that's not possible, as a last resort, something which is not mentioned on the slide, but keep it in mind anyway, last resort, a design around of your product, if possible, to make sure that it is not captured by a patent which cannot be revoked. That's it from us for the time being. We're happy to address any questions in the Q&A. Thank you for listening to us. You have our contact details in case you would like to contact us later on. Thank you very much.